The day Poston's tail started wagging in iambic pentameter and Latin maxims, nobody was prepared. Least of all the humans. People expected the usual Monday groans, potholes and coffee so strong it could solder metal, not a dawn chorus of canines citing stare decisis. Yet at precisely 6:03 a.m., every single dog in town sat back on its haunches, cleared its throat, and announced, in flawless courtroom diction, that it would henceforth litigate for enhanced alimentary compensation, to wit, more treats, forthwith, and without undue delay. I found out because my beagle, Baxter, filed his petition while I was brushing my teeth. Louisa Puddlewick, he declared from the hallway, whereas I have faithfully executed the duties of emotional support mammal, and whereas you have consistently rationed my biscuit allotment, I hereby serve upon you this formal notice of intent to sue. Please govern yourself accordingly. I spat mint foam into the sink and stared. Baxter stood there, wearing the smug expression of an 8th grade valedictorian who'd memorized the footnotes. You're talking. Objection. I have always communicated. You simply lacked the auditory acuity to apprehend my oratory. Now, if you would acknowledge receipt of these documents. He dropped a rolled-up paper by my slippers. A summons drafted in 12-point Times New Roman, printed on something that looked suspiciously like my good resume paper. The heading read, Superior Court of Poston, Canine Division. Some people would faint. I, unfortunately, own the sort of brain that would rather find coffee than panic. I padded to the kitchen. Baxter followed, claws clicking like a stenographer's keys. Across town, similar scenes played out. Mrs. Flores' Chihuahua, Consuela, demanded reparations for unlawful lap occupancy interruptions. The mayor's labradoodle, Sir Waggington, delivered a 60-page injunction against the municipal firework budget, citing egregious violations of auditory tranquility. By 8 o'clock, Poston's inboxes clogged with cease and desist letters and motions to compel the immediate disbursement of peanut butter-flavored equity. The human attorneys were the first to panic. Hank Wrigley, who normally charged $300 an hour to threaten semicolon misuse, realized overnight that every potential client had grown 4 legs, a tail, and 0 need for counsel. The dogs represented themselves pro bono, and their legal research was impeccable. Someone later discovered they'd downloaded every case file off an abandoned cloud server called Barclay I. By mid-morning, Main Street sounded like a bar association mixer inside a kennel. Dogs gathered in clusters, swapping citations to Papa v. Squirrel, 1963, and the seminal treat rights case of Milkbone versus Johnson, 1994. They wore neckties as bandanas and balanced reading glasses on snouts. When a dachshund couldn't reach the lectern at the impromptu town square press conference, a St. Bernard simply hoisted him up and whispered, "Remember Rule 11, no frivolous whining." Mayor Trudy Carver scheduled an emergency council meeting. Half the chairs were replaced by oversized dog beds. She opened with a tremulous gavel tap. This special session will come to order. Point of order, barked Sir Waggington, rising on hind legs, tail curled with parliamentary rigor. Pursuant to the Open Bark Meetings Act, subsection Wolf, we insist kibble be made available at all public gatherings exceeding 30 minutes. Nobody argued. The town clerk fetched a bulk bag of kibble, scattering it down the aisle like legislative confetti. The dogs nodded, satisfied, and proceedings continued. I sat in the audience, clutching Baxter's yet unanswered lawsuit. He'd listed grievances. A. Restriction to a single bedtime biscuit. B. Arbitrary and capricious prohibition of sofa access on laundry days. C. Emotional distress caused by grooming video parodies posted to Instagram without his informed consent. damages sought. All the treats that fit inside the sunroom ottoman with interest. Councilwoman Gabe Rossi leaned into her microphone. We can't go to court against every dog. There are 6,000 in Boston. A pug named Delilah adjusted her polka dot bow tie. Correction. There are 6,027 canines, of which 6,027 intend to litigate. Consolidation into a class action is preferable, but we will not hesitate to file individually if settlement negotiations stall. Settlement of what precisely? Asked Rossi. An across-the-board treat increase of no less than 200%, guaranteed belly rub parity, and a constitutional amendment ensuring the right to sniff whichever lamppost we deem fit, free from time constraints. Gasps erupted. Someone spilled a carafe. A local blogger live streaming the event wrote in all caps, "The dogs are unionizing, and they have better draftsmen than we do." The mayor attempted conciliation. Dogs of Boston, might we appoint a joint task force? Sir Waggington conferred with a Greyhound stenographer, then replied, "We accept, provided said task force be named the Committee on Human-Canine Relations." Acronym CHCR, pronounced Snicker, and composed of equal numbers of bipeds and quadrupeds. Additionally, snacks must be provided every 15 minutes. Motion carried unanimously, mostly because refusal risked being labeled anti-dog in an election year. 2 hours later, CHCR assembled in the municipal auditorium, where folding chairs shared floor space with chew toys. My presence owed to Baxter's nomination of me as Opposing Party Representative 1, OPR1. A golden retriever in wire-rimmed glasses, Miss Clementine, presided as neutral mediator. "Let us dispense with pleasantries," she said, clicking a laser pointer at a PowerPoint slide titled Treat Equity Framework. Our research indicates a 63% disparity between the current treat provision and the Canine Recommended Daily Enjoyment Index, CRDEI. A terrier raised his paw. Point of inquiry. Does the index adjust for size variance? Indeed. We apply a formula factoring weight, metabolic rate, and good girl boy frequency. I whispered to Baxter, "You did all this math?" "Spreadsheet macros," he murmured, not breaking eye contact with the screen. The human delegation countered with a budget projection. Feeding every dog 200% more treats would bankrupt Boston by Christmas. The librarian, Mrs. Headington, suggested raising sales tax on squeaky toys to compensate, but the dogs objected. Regressive. Tensions escalated when the dachshund from earlier, a litigator nicknamed Saul Longbody, slid a thick binder across the table, titled Alternative Dispute Resolution, Threats and Consequences. Page 1 read, "We know where you hide the bacon." I cleared my throat. "Dogs, friends, country pets, lend me your ears, floppy though they be. Surely we want a fair arrangement, not an arms race over the treat jar." Ms. Clementine nodded. "We agree. Shall we propose a structured walk and talk to cool tempers? Perhaps a class stroll around Lake Woofington. And so, for the first time in Boston's history, labor negotiations recessed for a constitutional sniff break. We paraded down Maple Avenue, beagles citing subclauses beside retirees clutching notepads. Reporters recorded everything. One quipped, "This is the only picket line that fetches." During the walk, Baxter confessed the origin of the canine legal awakening. Someone left a continuing education audiobook playing overnight. Contracts, case law, and corgis, an unlikely trio. We absorbed it through osmosis. Combined with our innate sense of justice regarding edible entitlements, the result was inevitable. I laughed to spite myself. "Be honest, Bax. Is this really about treats, or, I don't know, attention?" He slowed, ears tilting. "Can it be both? The jurisprudence of love and Alpo is not mutually exclusive. As we rounded the boathouse, Pa's steps fell into silence, except for the lapping waves. An idea hit me like a wet tennis ball. What if we institute a performance-based reward structure? More walks, more training games, more enrichment, plus sufficient treats to match the exercise. He pondered. A quid pro bono. Exactly. Make it about health, stimulation, relationship. We humans want you happy, not rotund. Back at CHCR, I outlined the Mutual Enrichment and Treat Sustainability Program, acronym METS, causing an audible groan from the dogs who preferred belly rubs and snacks kiosk, Brask. Nevertheless, we entered good faith bargaining. We hashed out treat tiers pegged to activity quotas, implemented a couch access after bath clause, and mandated weekly social excursions to the dog park. Dogs requested a sunset review clause. 6 months later, if humans reneged, automatic double treats would trigger. Humans requested one special protection. Cats should remain outside the agreement, because dragging felines into a canine union might collapse household peace. The dogs agreed, albeit attaching a no vendetta addendum in font size 8. Both sides left with tentative smiles, tongues hanging out, some literally. But compromise is easy on paper. Implementation, another howl entirely. The following morning, Boston Superior Court convened its first canine docket. Judge Penelope Hardwick, who normally spent her days juggling parking tickets, took the bench looking like she'd accidentally worn clown shoes to a funeral. The clerk called the matter of Barkington et al.v., Henderson et al., a consolidated action representing all dog plaintiffs citywide. In human speak, every dog was suing every owner simultaneously. A murmur rippled as the lead counsel padded forward. A border collie named Obadiah Fleet, wearing a waistcoat sewn from a picnic blanket. He addressed the court without a single Your Honor, we move to stay proceedings pending ratification of the Mets Accord, drafted during CHCR negotiations. Early indications show promise, but we require judicial oversight to ensure compliance. Judge Hardwick blinked behind her bifocals. Mr. Fleet, are you asking me to function as a chaperone for treat distribution? Precisely. A fiduciary tailkeeper, if you will. The judge pinched the bridge of her nose. I went to law school for this. Obadiah's ears perked hopefully. Yes, Your Honor. Baxter sat beside me at the defense table. Our roles had flipped. He'd become a sophisticated litigator. I, the nervous defendant. He whispered, "Offer her canine precedent. Judge Pepper in Fetch County oversaw the 2011 Snossage settlement." I rose. Your Honor, may I respond? She waved her gavel like a white flag. At this point, Miss Puddlewick, you could yodel the preamble, and I'd allow it. I explained the Mets plan, the proposed metrics, the sunset clause. I argued that judicial endorsement would lend legitimacy, quell community unrest, and, incidentally, save Boston from a tsunami of individual small claims treat suits. Opposing counsel, Obadiah, nodded in agreement. The dogs collectively wagged. Court-approved silent applause. The gallery, stuffed with curious citizens and at least 3 popcorn vendors, waited for the hammer to fall. Judge Hardwick sighed. Fine. I will place the agreement under the court's continuing jurisdiction. All parties must submit quarterly compliance reports, including, I suppose, photographs of happy dog faces. Verifiable grins, yes, Your Honor. Obadiah confirmed. So ordered. She banged the gavel. Now who's next? Something about a cat seeking restraining order against laser pointers. With that, the canine class action paused, pending harmony. Over the ensuing weeks, Boston transformed. Sidewalks buzzed like a treadmill showroom. Humans became amateur marathoners, motivated by 4-legged personal trainers. The town council installed hydration stations, water bowls shaped like miniature courthouses, every 3 blocks. Local entrepreneurs launched apps to track treat-to-exercise ratios. One startup, Poditor, allowed owners to upload proof of 20-minute fetch sessions to unlock digital treat coupons redeemable at participating pet stores. Baxter and I settled into a new rhythm: morning jogs, midday puzzle toys, evening dental chews. He still spoke legalese, but only when necessary. Once, hearing a squirrel taunt from the maple tree, he shouted, "Desist your chittering, or I shall seek injunctive relief!" Before giving chase. Old habits die hard. Not everyone embraced Mets. A rogue faction of bulldogs formed the party, opposed to restrictive treat standards, acronym ports. They argued the exercise requirement constituted overzealous paternalism. They planned civil disobedience, sitting motionless in the yard while staring meaningfully at doorbells. However, public opinion favored the compromise. Even Hank Wrigley, whose law practice had crumbled like stale biscotti, pivoted to canine compliance consultants and became a millionaire implementing the very rules that replaced him. One afternoon, Mayor Carver invited me, Baxter, and Obadiah Fleet for tea. She confessed Boston's tourism numbers had spiked. Families traveled miles to witness dogs negotiating snack contracts by the fountain. "We're thinking of branding the town," she said. "Boston, where justice is served with a side of gravy." Obadiah paw-typed something into his tablet. We would require a usage royalty. Naturally. 6 months passed, bringing the Sunset Review hearing. Judge Hardwick, now famous enough for a late-night cameo, reconvened the canine docket. Rows of dogs sported shiny coats and bright eyes, proof that Mets had not only fed them, but fit them. Humans looked leaner too, though perhaps that was the anxiety of making quarterly treat spreadsheets. The clerk called the case. Obadiah approached, wagged slow and dignified. "Your Honor, plaintiffs and defendants submit joint notice of satisfaction. The Mets program meets all nutritional, recreational, and relational metrics. We move to dismiss with prejudice, against future grumbling." Murmurs of anticipation filled the wood-paneled room. I stood. "We agree, Your Honor, though I'd like the record to reflect my personal appreciation for Baxter, who has taught me the law can be petting, and pets can be law." Judge Hardwick cocked an eyebrow. "Touching, Miss Puddlewick. Mr. Fleet, anything further?" Obadiah cleared his throat. "One minor matter. We request formal recognition of habeas biscuit, the right to immediate snack relief when held in car back seats longer than 30 minutes. Laughter rippled through the gallery. Even the judge chuckled. "Motion noted. I'll allow it under the doctrine of cuteness compelling. Gavel strike. Case dismissed." And just like that, the Great Treat War ended, not with a whimper, but a satisfied burp. As we filed out of court, reporters thrust microphones. "Baxter, were you nervous?" He adjusted his tie. "Justice delayed is kibble denied. I am pleased we avoided pause hostilities." Another asked me whether Boston might serve as a model for interspecies conflict resolution. I shrugged. "Listen to your dog. You'd be surprised what they know, and how well they know Latin." Life settled. The dog still spoke legalese, especially when negotiating a bathroom break during rainstorms, but mostly reverted to normal barking. Humans found themselves translating for tourists, explaining why a basset hound demanded expeditious removal of the postal carrier under the nuisance statute. Some nights I'd sit on the porch with Baxter, watching fireflies over the hedges. He'd rest his head on my knee, sighing contentedly. "You got what you wanted." I'd tease. "Half of it," he'd reply, eyes closing. "The rest is knowing you listened." Speaking of listening, I'd say, shaking a bag of biscuits. Time for your after-dinner precedent. He'd lift one eyelid. Exhibit A, please. We'd sit there, sharing silence and snacks under a sky with no court docket. Just stars, each twinkling like a pinhole punched through heaven's law library. Then one night, just before sleep, Baxter muttered drowsily, "Louisa, next month we renegotiate the belly rub clause." I stroked his floppy ears. "Talk to my counsel," I whispered. His tail thumped. "I am your counsel." Of course he was. Because that's what happens when dogs of Boston awaken to legal consciousness. They remind their humans that companionship is a binding contract, signed, not with ink, but with wagging tails, sloppy kisses, and yes, occasional demands for more treats. And frankly, after living through the chaos, I can testify under oath. It's a bargain worth litigating for, every single time.